Very good. Well, good afternoon, everyone. Another week with another great webinar to start in just a second. So we have today Christina Cavallari, attorney at Law for Small Business, supporting MBDA and all of our clients with a great presentation on the topic. Today, it's about understanding employment law compliance. So we actually get a lot of questions about that. So we're so happy Christina is here. Again, for everyone, this is being recorded, so they will be posted on our YouTube channel. Feel free to go to, you can just search New Mexico Minority Business Development Agency on YouTube, and all of our recordings of our webinars will be available there. If there's any questions throughout the webinar, feel free to post it in the chats, and we can make sure that Christina can, answer them right away. And if not, we'll let Christina take over. Go ahead.
All right, wonderful. Thank you. Thank you for having me. Sorry I'm in a conference room so that I wouldn't be disrupting my coworkers next to my office. So I've been asked to give a presentation about employment law for small businesses, which is one of the areas that I practice law in here at Law for Small Business. I built the presentation as we're going to talk about a lot of different things. If you are a small business owner who already has employees, a lot of it will be things you already know. As I put together this presentation, I found a couple of things that I realized were holes in my knowledge. So I hope that this can do that for some of you. And if you don't have employees yet, if you're thinking about getting employees, if you have questions about do you need an employee or an independent contractor, we're going to give the sort of broad strokes, high level. I want to put it in your mind. I don't expect you to retain everything from this presentation, but I want it to be the time when you're ready to hire, or when you're looking at your employee situation. I want you to have heard of these laws and rules and considerations. And so with that, I'll pull up my presentation. And as our wonderful host said, I will be trying to keep track of the chat. I have it open on the side. And I know that Gabriella and Sophia and Flor will also be looking at the chat. So if I see your question, I'll answer it in real time. If not, we'll go back at the end. I've tried to leave some time at the end as well for questions, but I'm happy to be interrupted. I don't like talking into the void, but I'm happy to do it for you. All right, here's my presentation. Okay. There we go. It tells me I'm screen sharing, so unless someone tells me that I am not, I will assume I am.
You're good.
Excellent, thank you. Okay, as I said, employment law basics for business owners. This is the firm where I work. This is the wonderful organization that's hosting. Okay, first I have a little disclaimer. I am going to be talking a lot about the law, and I am a lawyer, but this isn't legal advice because I don't know the individual circumstances that you are facing and dealing with. So please reach out to either me or my firm or any other licensed attorney for true formal legal advice if you want. And I will answer your questions, but still my answers to your questions. They're not legal advice because we don't have an attorney-client relationship. And that's what this says. This presentation does not create an attorney-client relationship. Please reach out to a licensed attorney if you would like to have an attorney-client relationship. So here's what we're going to talk about today. For employment law for small businesses, I went through in kind of the chronological life cycle of having employees. So hiring employees versus independent contractors, the selection considerations, then benefits and pay, minimum wage, overtime, benefits, taxes, and then termination. So that's sort of the process of having employees. And we're just going to go in that order. So the first thing when you are looking to hire help, you might be wondering if you need an employee or an independent contractor. And so I have this little chart that sort of shows the relative characteristics of employees and independent contractors. I'm sure that you're all pretty familiar in broad strokes with the difference, and this difference down here, the 1099 versus W-2, tends to be the first thing that you think about when you're thinking about whether you want a contractor or an employee. I don't think it should be the first thing you think about, but here we'll talk about it. So an employee gets a W-2 for the money that you pay them. You are required to withhold employment taxes, payroll taxes, and pay the employer's portion of the payroll taxes. And so an employee has an extra paperwork element and an extra tax element. For an independent contractor, you issue them a 1099 for the payments that you've made to them, and they're responsible for, because an independent contractor is its own small business. So they are responsible for their own self-employment taxes or employment taxes. And so when you're thinking about employees, your employees can be permanent, your independent contractors are more ephemeral, temporary or as needed for a specific service. An independent contractor should probably have multiple clients because they are their own small business offering different services. An example I like to use of an independent contractor is my friend Josh has a small business. He provides tech support services to other businesses. And so he doesn't want to be anybody's employee. He wants to be his own employee. He is self-employed. The businesses that hire him issue him a 1099 for the fees that he charges them. He has special skills that a business might not have. Most businesses need tech support. They need a tech consultant at some point. And it doesn't necessarily mean that those businesses are tech businesses. And we'll talk about that a little bit more, because if you try to hire, you need an employee, but you don't want to do this part and you hire an independent contractor, you can get in trouble. And the IRS in the state of New Mexico will say, well, you said that you hired an independent contractor, but you actually hired an employee, so you owe us a bunch of taxes. That's on the next slide. So you may have said that you hired an independent contractor, you could end up with an employee. The state government gets to decide if you've hired an employee or an independent contractor, the federal government, both under the Fair Labor Standards Act. So this would be that you haven't provided minimum wage and certain working conditions that are guaranteed to employees to your independent contractor. And then the IRS will say you haven't paid us your payroll taxes. I've done a whole presentation on this issue and I've condensed it to these 2 slides. So I summarized each of these. The state government, the federal government, and the IRS has different tests to determine, but all 3 tests pretty much lead to the same considerations. All 3 will look at, what is your contract? Does your contract say that the person that, you've hired Josh's company to do tech support, or does the contract look more like you've hired a tech support person just to work for you? You tell them their hours, you've given them a desk at your office, things that look more like an employee. So they'll look into the contract and they'll look a little bit beyond if the contract says independent contractor at the top into what is actually being offered by the worker to the business. The next question is, how much control can the employer exert over the employee or contractor? Employers exert a lot more control than businesses that have hired another business. And so that'll go to work hours, work location, the means by which the worker does the work. And so if the business controls the hours, the location, and the means, they're more likely to have an employee than a contractor. And then, is the employee an integral part of the employer's business? If you have an independent contractor who is working the cash register at your retail store, you likely have an employee that you're trying to pass off as an independent contractor. So if the contractor is doing your basic business functions, they're going to be an employee. And then how financially independent is the employee or the contractor? And this goes to, can this contractor advertise and seek other clients? Do they have a chance to, influence what their compensation is going to be through getting other clients? Or, they can, a big one that they look for is unreimbursed expenses. My friend Josh has to, pay for his own water cooler because he has his own business. If he were an employee who was sitting at an office at a desk, you would think that those business expenses would be reimbursed by the employer. So that's the basics of whether you need an employee or an independent contractor. So the rest of this presentation, except we're going to get into the tax part a little bit, again, we'll revisit independent contractors. The rest of this presentation, I'm going to assume that we went with an employee. We decided we're hiring employees. So in hiring considerations, and I can't see the chat anymore to see if there are
I don't see any questions. So
okay, thank you.
Yeah.
I might have to rely on our hosts to let me know if there are questions.
That's totally fine. We can do that.
Thank you so much. Okay, so hiring employees. The first thing that pretty much everything in hiring considerations, there are some prohibited questions on job applications. I didn't go into what's prohibited on a job application versus what's prohibited in terms of making the decision, because they're sort of the same things. So this ban the box statute that New Mexico passed basically says that you cannot have on a job application a checkbox for, do you have a criminal history? And they got rid of that because they were finding that employers were just looking at that checkbox, and if someone had been convicted of a crime, they just were throwing out that application. And so the ban the box means that checkbox can't be on your job application anymore. I think that if you're asking questions specifically targeted to get this information on your job application, you shouldn't. Because that sets up that potential employee, that applicant, to say, well, they asked me if I smoked and I didn't get the job. So they used prohibited discrimination in hiring. So I think if it's not something you're allowed to consider to make your employment decision, it shouldn't probably be a question on your job application. And so New Mexico has broader protections for groups than the federal government. Most states do. Most states have passed at least some of these additional things. So race, age, religion, color, national origin and ancestry, and sex and military status. These are the big ones for the federal government and the state of New Mexico. Those are the double. Physical or mental disability is also federally protected and protected by New Mexico state law. It's just in a different section. And the Americans with Disabilities Act comes into play for the disability protections. Serious medical condition, this is a New Mexico a specific statute, which includes HIV status. So that applicants can't be discriminated against based on HIV status. Spousal affiliation, that where the spouse works, and political affiliation, I think, are protected. Sexual orientation is not protected in all states, but it is in New Mexico, as are gender and gender identity, which are not protected in all states. Pregnancy is protected by the federal government under the Americans with Disabilities Act, and under some case law having to do with sex. Criminal history is a protection guaranteed in New Mexico, as are smoking and genetic information. The smoking is interesting. Hiring decisions and firing decisions can't be based on smoking, and this is for tobacco. Our Compassionate Use Act for cannabis also, I probably should have included cannabis on this slide. New Mexico hasn't passed a statute that protects workers from discrimination based on cannabis use, but best practice is that is not a reason to disqualify someone from consideration. And then genetic information. This was a big scare for health insurance reasons, where we were finding that we could test genetically for predisposition to serious medical conditions. And the law wasn't keeping up with employment discrimination. Like if you found out you had a likelihood of developing a serious medical condition like Huntington's disease, employers could discriminate. They can't do it in New Mexico. So these are not reasons, not things to consider when you hire. Asking about them, it's kind of that I recommend in job interviews not to ask questions about these specific things, and not to try to glean them using your interview questions. And so that can be kind of tricky. There are model interview questions available all over the internet that are aimed to avoid treading on these. And it's nice before you interview to, pull some model interview questions just to sort of get an idea of if your interview tactics are kind of in line with what the best practices are. Reasonable accommodation, and this is for I may have said some things like physical or mental disability, and you said, but wait, what about? And it would be, but wait, what about lifting requirements that you see in job postings? What about standing requirements? And for HIV status, I think you might have said, well, what about the cases where there have been some dentists and some doctors who have infected their patients with HIV. Certain jobs can have requirements that cannot be met by some candidates. And so the Americans with Disabilities Act and the various state laws that provide these protections say if you have a job candidate who doesn't match up with the job requirements, the question is, could a reasonable accommodation be made that would allow that worker to do that job? Reasonable accommodation is all over the place. It's wild. And so grocery store checkers, I would think that allowing them to sit would be a reasonable accommodation, but that has been brought up a lot of times, and the standing requirement for grocery checkers is upheld. And so if you have a lifting standing requirement or a status requirement, you want to make sure before you even hire that you have a reason, you have your justification in order for why the job requires those characteristics. And then if you get a candidate who needs an accommodation, really do some soul searching and get some professional advice about whether that accommodation is reasonable, or if you can deny consideration to that candidate because of the requirement. The smoking one as well, but wait, what about you can't smoke in my office? That is fine. It's just you can't discriminate based on someone's status as a smoker in their own time. You certainly can require that the indoor and outdoor smoking bans be followed. Background checks. So when you hire, I recommend checking references and checking backgrounds if it's required. Background checks are required if the employee is going to work with children or vulnerable populations. Checking references, I highly recommend. We have tort liability in New Mexico, and I think there is liability in most states for something called negligent hiring. And so if you hire someone to be have a runner, that would be a good example, because if you hire someone to be a delivery driver, there are a lot of background checks that are required. But if you were hiring a young person or an older person, just someone to serve as a runner, to go and deliver things to the court maybe, or to get you coffee, and they caused a serious accident and somebody died, and then it turned out that they had a long record of reckless driving, that plaintiff's attorney will likely be looking to your business as a defendant in the lawsuit, and they'll say, you didn't even check to see if they were a safe driver, and then you had them in a job where they were doing a lot of driving. And so it's important for business reasons to check references and maybe do a background check. It's also important for this negligent hiring liability. This is cool. I like this because there's a misconception. So there is an immunity, it's limited immunity for former employers providing good faith references. I was told, oh, I took that out. So I was told at one point that all that I could say in a job reference was that the candidate is eligible for rehire or not eligible for rehire. That's a myth. In fact, there is immunity from suits if you are providing a reference in good faith. So you can't get sued even for defamation, even if it would otherwise qualify as defamation. It's false, it's defamatory, there are damages. You can't get sued as long as you're not doing it maliciously. Like if you actually believed what you said to be true, then you can't be sued. Let's see. Okay, post-hire. So those were our hiring considerations. As just sort of as a general matter, in an at-will state and just kind of in general, hire people who you think will be a good fit. Hire them not based on any of the prohibited considerations, and you should really be fine. Okay, so now you've hired an employee. What do you need to do? You need to follow the Immigration Reform and Control Act. That's where this I-9 form comes from. All employers have to do it. It also says you can't discriminate based on immigration status. And then there's the but wait. If the worker's not authorized to work in the US, you can't hire them. But you can't discriminate based on a citizen versus a authorized worker under a green card or other work authorization. And this is where this I-9 form requirement comes from. You are required to personally examine 2 forms of identification from column A and column B and fill out this form. Post-hire contracts. So we'll talk about New Mexico and most states are at-will states. So that means that an employee can quit or be fired at will. Just you didn't like the employee, they didn't work out, the employee doesn't like the job, gets a different job. You want to hire your nephew to do the job that's already occupied by a current employee. It's an at-will jurisdiction, so you can, that's a perfectly fair reason well, it's not fair, but it's a perfectly legal reason to fire someone. You just need to avoid those discriminatory reasons, and I have a slide about that in the termination section. So this default at will employment can be changed by contract. And so it's a big tenet in this area of law for me to warn you about employment contracts. If you want to retain this at will employment status, then don't get an employment contract. And so you'll notice on most offer letters, offers of employment, they will say, and probably in bold and all caps, that this document does not create an employment contract and does not change the at-will nature of this job. So you might want an employment contract. You might need an employment contract. If you are paying someone on commission, there's certainly going to be some amount of employment contract involved in that, because how do you know what their commission they're entitled to is without a contract? Employment contracts can be written or implied. So even if you don't have a written contract, if you make a bunch of promises to someone, you might have an employment contract. And then employment contracts can be collective or individual. So if you are using union labor, there will be a union contract, and that changes this at will as well. Other contracts you might use, you might currently use some, this is a big deal, this just happened. Covenants not to compete are pretty widely used. They used to be enforceable in New Mexico, and they still are until August, when they will become unenforceable in the entire United States. Covenants not to compete, if you're not familiar with them, they're a little thing usually in either a standalone agreement or in a confidentiality, non-disclosure, non-solicitation agreement that says, I promise that I will not do a competing job with your business. They need to be limited in time and geographical area. So like, I promise I won't act as a massage therapist in Santa Fe County for 2 years from the date of my termination or resignation from this job. These are unenforceable beginning in August. They tend to be pretty bad for workers because workers can't, support themselves, do work to support themselves. So they tend to be pretty widely used by businesses. And so this is pretty burdensome to businesses. And so you won't be surprised to know, oh, something just popped out. Nicholas posted that he disagrees with the non-compete date. That is the date that the rule will go into effect. And what I was just going to say is that the Chamber of Commerce and other business groups have filed lawsuits to invalidate the rule. A court has not yet said that the effectiveness of the rule will be stopped pending litigation. It's entirely possible that that will happen. And it's possible that a court will overturn this, but as of today, this is going into effect in August. The courts are pretty notoriously conservative right now, and if you were, I don't know that this falls along conservative versus liberal, camps, but the conservative courts are probably going to be pretty against this rule, and so it may be overturned, but it hasn't been yet. So this means that in either event, if this is overturned by a court or limited by a court, or if it's upheld, businesses will probably look to their confidentiality, non-disclosure, non-solicitation agreements to provide them some of the protections that used to be provided by covenants not to compete. because those have not been messed with. And so confidentiality agreements apply to the protection of your trade secrets. And so you may be able to prevent employees from, taking all of your trade secrets and then going to your competitor with them. Same with non-disclosure. Non-solicitation, that is that your employees won't take your customer list and then call everyone on it and be like, hey, I'm at this new place now, you should follow me. So those are still enforceable, even if the rule goes into effect as scheduled. All right. Other hiring considerations, wages. As you know, employers have to pay their employees either a salary or an hourly wage for all hours worked. The damages for failure to pay wages is, an employee who brings a successful wage claim will get their attorney's fees, which can be larger than the wage claim, and then they will get 3 times the amount that they were not paid. And this is to sort of balance the scales for lower wage employees, to make it more possible for them to pursue an unpaid wage claim. The minimum wage is a complicated a jungle to navigate, because there is a federal minimum wage, a state minimum wage, a county minimum wage, and a city minimum wage. Not all cities and counties have adopted minimum wage ordinances, but all states and federal governments and the federal government has. The minimum wage you have to pay will be the highest minimum wage applicable to the place the employee is working. For remote workers, you could potentially litigate about whether the company's principal place of business determines the minimum wage, or the workers where they sit determines the minimum wage. I would probably just apply the highest one to be safe. I don't know if there are a lot of minimum wage workers working from home anyway, but there's a different minimum wage for tipped and untipped workers. So that this has to do with, servers in restaurants and people who make tips. And the minimum wage statutes generally require posting of the poster in English and Spanish in the workplace, notifying the workers of their rights. Usually this poster gets changed every year, so it's a expense to build into your annual business expenses of ordering new posters. So in New Mexico, we have some stuff happening, especially in Albuquerque with the minimum wage. So the state of New Mexico, and I didn't put the federal minimum wage on here, which is $7, and I never remember what it is. I'll tell you. But minimum wages in New Mexico. So the state has a $12 an hour minimum wage. Their tipped minimum wage is $3 because they figure that the tips will come in and raise that up. Santa Fe County, and this is interesting. So the Santa Fe County minimum wage kept up with this cost of living adjustment, but the city of Santa Fe didn't. And so the county's ordinance says that it applies only to unincorporated Santa Fe County. I would still kind of be worried about this. It's hugely frustrating to the Restaurant Association because it's hard to tell which one applies. Las Cruces has kept up with their cost of living and increases, and so they've gone up. Albuquerque was supposed to keep up with their cost of living increases and failed to, so they have a new ordinance that's currently being considered, which would keep their minimum wage would match the state's and then have an annual cost of living increase, but their tipped minimum wage is 60%, which makes it the highest. That would make it the highest in the state and would really change. I don't know that restaurants are super opposed to paying their tipped servers more, but it does mean that they have to redo all of their payroll, and that, you know, if they have a location in Bernalillo County and in Albuquerque, or one in Santa Fe and one in Albuquerque, it's just massively confusing. But this is being considered by the Albuquerque City Council right now, and it will probably pass. So that's just to say, when you're paying, if you're paying minimum wage, make sure that you're following you check all of the different jurisdictions and make sure that you're paying the highest minimum wage applicable to your business. Overtime, both hourly and salaried employees may be entitled to overtime pay, which is 1.5 times the employee's normal hourly rate. Hourly employees are entitled to overtime pay for all hours worked over 40 in a calendar week. Just make sure you're consistent with your calendar weeks. So you can choose if it starts on Saturday and ends on Sunday, or if it starts on Monday and ends on Sunday, but just make sure it's consistent. Salaried employees who make under $35,568 per year are also entitled to overtime pay for hours worked over 40 in a calendar week. This is new-ish. It was always true, but I think they raised this amount to reflect inflation and cost of living. So salaried employees who make over $35,568 per year, they might also be entitled to overtime pay. And the rule of thumb, because here are the overtime exemption categories. So the salaried employee who makes under that threshold amount also has to fall into one of these categories. And you'll notice it's for executives, administrative assistants, or administrative staff, professionals, computer employees, outside sales, and highly compensated employees. And if you look at all of those, what they have in common is that these are desk jobs. I think what they don't want is salaried employees who they say they make $40,000 a year and they are doing highly physical jobs. They want them to get overtime for those highly physical jobs. Benefits, that's the next part. There's some federally mandated benefits. Those are the minimum wage and overtime, which we just talked about. The Family Medical Leave Act is a federal law, and it applies to businesses with 50 or more employees. And it's eligible employees, so those are employees who have worked for 12 months for the company, 1,250 hours or more in the last 12 months, can take up to 12 work weeks of unpaid leave for an illness or new childcare. So it's unpaid leave. It's basically like, we'll save your seat. We'll save your job for you while you have that baby, if you can get back in 12 weeks. COBRA, that's the continuation of benefits law. And it says departing employees can continue their health insurance coverage. They have to pay for it, but it allows them to stay on some sort of health insurance. And workers' compensation is state run, but it's mandated by the federal government. It's a required insurance policy bought by the employer to cover on-the-job injuries to employees. State mandated benefits, the Paid Sick Leave Act, the Healthy Workplaces Act. This came into effect in 2022, so it's newish. New Mexico employers must offer 64 hours, 8 days of paid sick leave annually. And that's accrued 1 hour for every 30 hours worked. So it's about 1 hour per work week of paid sick time. And that was in response to people having to work sick with COVID and getting, spreading more. We decided it was a good idea for sick people to be able to stay home. Unemployment compensation. Certain employees are eligible for unemployment upon termination or severance. Usually those are employees who are laid off or fired, but there are exceptions for being fired for cause and for employees who quit. Employers pay into the state unemployment insurance fund So it's important to be in good standing with the state, and pay everything that the business is required to pay. New Mexico has a mini COBRA that extends COBRA coverage for up to 6 months. The federal COBRA is shorter, and so most states have extended COBRA for some amount of time, and we've extended it to 6 months. We also have the New Mexico Kin Care Law, which says that if an employee gets sick leave, the employer is required to honor the sick leave if the employee isn't sick, but the employee's family kin is sick. So it just uses existing sick leave and applies it to family sicknesses. Jury duty and voting leave, you have to give leave for jury duty and voting. 2 hours for voting. New Mexico also has the gender neutral bathroom requirement, where employers have to provide a general gender neutral bathroom for their employees. Other benefits considerations, this is just something I didn't know where to stick it. But if you are offering benefits to any of your employees, you have to offer them to all of your employees who are similarly situated. So you don't have to offer benefits to your part-time employees, but if you're offering benefits to any full-time employees, it has to be to all of the full-time employees. And so that prevents the business owners from getting themselves health insurance and not extending that tax exempt health insurance to their other full-time employees. Businesses can require that the employee pay a portion of those benefits. So it's not exactly, you could pretty much exclude all of your lower wage workers from your benefits by just making their portion of the contribution too high for them to afford. So it's a protection that doesn't necessarily have a lot of meat behind it. Reporting, this is the thing that I wasn't aware of the seriousness of it. So there's a New Mexico new hire directory. Employers are supposed to report newly hired or rehired workers within 20 days of hire or rehire to this New Mexico new hire directory. Here is the website. It comes with some penalties if you fail to do it. I think it's a pattern of failing to do it, but it's important to report your newly hired workers to the state. Taxes, we talked about when you have an employee, you're required to pay the employer's portion of the payroll taxes and withhold the employee's portion from their checks. If you're withholding federal taxes, you also have to, the employer is required to also withhold the state taxes. This is a good place to seek professional help from a good bookkeeper or CPA, or get, if that's not achievable or attainable, I recommend getting some good software. But yeah, a CPA is really a great resource to start utilizing here. And then this is where I promised we'll go back to independent contractors. Gross receipts tax applies to services. That is the New Mexico, what we have instead of a sales tax. And where I see a lot of problems with services is the contractual arrangements, the bundled services, and the non-taxable transaction certificates. And so bundled services only have to be taxed once for gross receipts tax. So that would be, say you have a spa, and the spa has a independent contractor, facial professional, esthetician. And the contractual arrangement would be the spa agrees to collect and pay the gross receipts tax. The esthetician should really make sure that that is happening, because that person can end up getting a letter from the state of New Mexico saying, where's our gross receipts tax for all these services? So this is a little bit scary for the independent contractor. Bundled services, so say the esthetician services were bundled with the massage therapist services and some other service. Those can be bundled and only taxed once, as like the spa package or the spa's income. And non-taxable transaction certificates are supposed to be obtained from the state of New Mexico. Anytime that you do a bundled service or, food is not taxable. Anytime a transaction isn't taxable, you're technically supposed to get one of these. In practice, I don't see a lot of people comply with this. Gross receipts tax reporting and paying is really confusing and difficult to comply with, even for the professionals. But if you have access to a professional, I do recommend utilizing that. Okay, termination. Let's talk first about firing. This is just a copy of the slide from the hiring considerations. You cannot fire someone based on one of these protected statuses. You also cannot fire someone in retaliation. So an employee can't be fired for reporting a workplace safety issue, a hostile work environment, discrimination. And basically the broad strokes of that is that exercising legal rights cannot be grounds for termination. And that is a little bit limited. I get a fair amount of people coming to me saying I was fired for my, we saw it in the January 6th and other major demonstrations. People get fired from their jobs for participating in protests or political action. Those are really hard, and they call me and they say, can I sue for this? And those are really hard lawsuits to maintain because we are an at-will state. And showing up at a protest, it's not on this list. And so that's a hard one. So an at-will employment means an employee can be fired for any reason except for those discriminatory reasons. This is hard. I advise a lot of people who are not wanting to hurt someone's feelings, and they say, I have this employee, she's terrible. She's rude on the phone, she's disorganized, she can't get the work done. And they say, I don't want to hurt her feelings, so how do I fire her? And I say, you have to be honest, because those are legitimate reasons to fire her. And if you don't give her any reasons, then she's going to use her imagination. And she might use her imagination to say they fired me because of my military status. They don't like that I'm a veteran. And so it's hard, but it's important to be honest. This is where it makes sense to have an employee handbook so that you can point to where in the employee handbook the problem is. And it makes sense to have a PIP. And if you don't know about a PIP, PIPs are performance improvement plans, and they say the shortcomings of the employee's performance and what the plan is to improve that, and what the consequences will be if it's not improved. So that is a paper trail for, you give the PIP and then you give a first warning and a second warning, and then the third, or you can do a PIP and a first warning and then a termination. It's up to you. But it is a paper trail to show that it was a performance issue that led to your termination and not one of these. So, okay. I think, there we go. One other thing I thought I had in here, I think it's why quitting. Because we're an at-will state, employees can quit when they want. The 2-week notice is an etiquette point. And sometimes it's longer for attorneys. Usually it's at least a 30-day notice, is also etiquette. In an at-will employment scheme, an employee can be fired without notice, and an employee can also quit without notice. Let's see, resources, and this should not be termination considerations up there, but the New Mexico Minority Business Development Association is a great resource. The New Mexico State Bar has helplines, so you can call into the New Mexico State Bar and get a lot of questions answered that way, basic questions. The New Mexico Department of Workforce Solutions has a lot of information on their website, and then you can also call them. They're a little harder to get a hold of. The U.S. Department of Labor also has a lot of information on their website about minimum wages, taxes, the federal protections for workers that need to be followed. Our website, Law for Small Business, this is the only pitch I'll really make for us. We have a pretty detailed blog on the website, and so a lot of questions, there might be a post written by an attorney on our blog. It's years of archived material. And then we're also available to answer questions and help with things too. And so that is all I jammed in there. And now we do have a little bit of time for questions if there are any.
Thank you so much, Christina. Let's see, do we have any questions from the group? I don't see any other questions. So I guess if there's no other questions, we can end early unless you have any other tips for us. This was super helpful. And also I appreciate how everything is with the information that's very current off the press, but also recognizing that things might change in 6 months from now or something like that. So that's great.
Yeah, it's a really active time in this area of law. I think it was pretty stagnant. We didn't have a minimum wage increase for many years. And I think with the pandemic, things are very active in this area of law.
Mm-hmm. Yeah. Oh, and then Nick is saying thank you.
Well, thank you, Nick. Thank you for your question.
Mm-hmm. Very good. Well, if there's no other questions, we appreciate your time, everyone's time, business owners, and of course, Christina. Thank you so much for this very informative presentation. And again, this will be recorded. Everyone can go back to it, and we'll also have access to the presentation, and we can send it out. Very good. Well, have a great afternoon, everyone. I'll talk soon. Bye.
Thank you. You too.